question for you. Does your state's estate plan work for you? And you might be saying, what do you mean, does my state's estate plan work for me? Well, you have an estate plan whether you know it or not. If you've gone to an attorney and you've worked with your attorney and you've created your estate plan, then you have your own estate plan that you want, that we know works for you because you worked with your attorney. Let's say you haven't gone to the lawyer and you haven't prepared an estate plan. Well, it might come as a surprise, but you have an estate plan. It just happens to be the state's estate plan for you. By default, you have an estate plan. So let's talk about what the state's estate plan is for you if you've done no estate planning yourself. During your lifetime, what happens to you if you should become incapacitated, if you can't manage your own affairs? Then the state's estate plan for you is you will be subject to a guardianship and a conservatorship under the court's supervision. Not a good result. Fix that by getting a durable power of attorney. Let's talk about what the state's estate plan for you is if you pass away without having any estate plan in place. What's going to happen next? The state says they think you would want your assets to go to your spouse if you're married. I'm talking about the state of Washington right now. State of Washington is a community property state, and that you and your spouse may very well have just community property, and the state says, well, I think that you would want everything that you have to go to your spouse. That might work for you. Let's say you're a single person and you don't have an estate plan. What does the state say happens upon your death? Well, the state looks and says, if you're single, do you have children? Yes, let's say you have 4 children. Then the state says, everything that you own goes equally to your 4 kids. Let's say you don't have kids, and the state says, do you have parents? Then your assets should go up to your parents. Let's say your parents are deceased. Then the state says, oh, let's look toward your siblings. They get whatever you own and equally. Now, when I'm talking about the state's estate plan when you don't have your own, this is called the laws of intestacy. The laws of intestacy means you don't have a will. Laws of intestacy govern probate assets. What's probate versus what's non-probate? Probate assets are those that would be governed by your will, or if you don't have a will, they are governed by where the state says those asset goes. So let's talk about what is a probate asset, what goes under a will. That would be your house, that would be your car, that would be any bank accounts that are only in your name and that don't have any direction on them. Any assets that have nowhere to go because you haven't given them any direction, those are called probate assets, and those go under your will, or if you don't have them, they go under the state's plan for you under the laws of intestacy. Now, where this gets a little bit confusing is that what's a non-probate asset, what doesn't go under the state's estate plan for you. That would be, for example, a bank account. Maybe you own it jointly with your sister, and on your death, your sister gets your bank account. Or maybe you have a life insurance policy that you have paying on your death to somebody else. That again is another non-probate asset. What these assets have in common is that they have direction. Somehow you put on these accounts, these assets, direction where they should pay on your death. So if you did that, and oftentimes if you're working and you have a 401k, part of setting up that account is you're asked to fill out a beneficiary designation. So that account will pay where you said it should pay because you put a beneficiary designation on it. If for some reason you don't have a beneficiary designation on an account or pay on death on an account, then it's directionless and it will pass under your will if you have one. And if you don't have one, it'll pass under the laws of intestacy and go where the state says it should go or where it thinks you would want it to go. What should you do at this point? I highly recommend that you put in a plan in place that is your plan, that's not the state's plan, one that would avoid probate if there's no benefit to a probate, or use a probate if probate protects assets, protects against creditors. There's myriad reasons why a probate might be a really good idea. All of this is really hard to figure out on your own. That's why I'd suggest to you to go see an attorney who can help you with this.